patients, just making sure that all of the presenters are on. We're all flung across the country and including in Haiti, so we really appreciate your patience, and we'll get started here in about 30 seconds or so. We see some additional attendees are still coming on. Just wait until that slows down, and then we'll get started and start the recording as well. So. Okay, we'll go ahead and get started. Welcome to everybody who's made it on so far. My name is Blaine Bookey, and I'm with the Center for Gender and Refugee Studies at UC Hastings Law School. Thank you so much for joining us and for all of the critical work that you are doing to support Haitians finding protection in the United States during this particularly difficult time for asylum seekers in our country. We have been truly overwhelmed and overjoyed by the outpouring of support and interest. Please note that we are recording this webinar, so the recording and the slides will be available after for all of you, as well as anybody else that you might know who was interested but couldn't make it. Please also note that in this very limited time, we'll only really be able to scratch the surface of all of these important issues very specific to the merits of Haitian asylum claims. And we hope to have additional resources available in the future, and we'll talk a little bit more about that during the webinar. And we'll also really rely on all of you to share your resources and strategies as we work together in the months and years to come. So today you'll be hearing from me, as well as Brian Kincannon, Steve Forrester, and Nicole Phillips with the Institute for Justice and Democracy in Haiti, as well as clinical professor Deborah Anker at Harvard, and hopefully Clara Syria, an immigration attorney with significant experience working with Haitians. So we hope that that he's able to join us.
Can you hear me?
Oh yes, we can. Fantastic. I'm glad you made it.
Yes.
Okay, I would now like to pass it off to Steve Forrester at IJDH to say a few introductory remarks before I share a little bit more about what we'll be covering in today's webinar. Steve? While we're waiting for Steve.
I'm sorry, I was on mute. I simply want to encourage people to visit our Haiti Asylum Information Project web pages with rights reports, articles, and affidavits. For example, we just added a memo on land disputes. And secondly, I want to encourage anyone who hasn't already done so to join the Haiti Deportations Response Network with about 200 members. We've been able to connect experienced interpreters with attorneys needing them, and attorneys with other attorneys needing appellate or other assistance, and we shared research, et cetera. So, and lastly, I'd like very much to hear from anyone who's seen procedural abuses of any kind in the taking of sworn statements or otherwise. So those are the things I just wanted to say right now. Thank you.
Great, thanks so much, Steve. We'll have a slide at the end of the presentation that has more information about both of those resources and networks that Steve mentioned with contact information. Before I move on to this webinar, roadmap for this webinar, I wanted to give a special thank you to Clinic for hosting this webinar. We had such interest that our webinar software here at Hastings wasn't able to accommodate the number of people that wanted to attend. So we are deeply, deeply appreciative of Clinic jumping in and taking on this role of hosting the webinar. So what will we cover in this webinar today? First, we'll hear from experts on conditions on the ground in Haiti, including from an expert who's currently in Haiti, to contextualize some of the claims that you are hearing from your clients. Secondly, we'll hear from attorneys who have been working with Haitian asylum seekers for many decades to provide some tips and best practices for working successfully with this population to build claims. Next, you'll hear from one of the leading asylum scholars, Professor Debbie Anker, on how facts of Haitian claims fit into the asylum framework and strategies for before proving those claims. I'll then share some thoughts on the impact of Haitians residents in Brazil before coming to the United States on their asylum claims. And finally, we'll share information on the resources that I just mentioned and that Steve introduced that exist to support all of your work with Haitian asylum seekers. And there will be an opportunity for questions at the end. So with that, I just wanted to give another reminder that there's just only so much we can cover during this time, and we'll do our best and look forward to hearing from you after the webinar about what else would be useful for you. So with that, I'll turn it over to Brian and Nicole.
Thanks, Blaine. This is Brian Concanon of the Institute for Justice and Democracy in Haiti. And some quick background on what we do at IJDH, just so you know where our information is coming from. We work along with our partner organization. It's called the Bureau des Avocats Internationaux in Haiti. And we work to try to make the Haitian justice system work for people. We try to build the rule of law in Haiti and bring Haitians' fight for justice to the international community. Steve, my colleague Steve, who you hear from later, has been working on Haitian refugee issues, mostly based out of Miami since the 1980s. I've been working on Haitian human rights issues since the 1990s, and Nicole Phillips has been working on these issues for over 10 years. So we've got pretty good information on the ground. We try to make cases work in Haiti. We do international litigation, and all that generates our country condition information. A quick roadmap of what we're trying to cover on this. We'd like to do a very brief overview. All this, of course, is impossible in 25 minutes, and I beg your indulgence and look forward to hearing what other kind of webinars we can do that get more in depth into some of these issues. But we'll give a quick overview of Haiti's political situation, talk a little bit about law enforcement justice issues as they relate to asylum, talk a little bit about politics, and then address 4 different categories that seem to come up frequently in asylum hearings, and finally talk about the opportunities for resettling in Haiti. In terms of the overview, Haiti's had a history of instability and dictatorships. By some counts, 133 coups d'etats. And some of those have internal causes in Haiti, some have external causes, most have a mix of the two. But what you've been left with is a government that has never had the opportunity to create the capacity to deliver basic government services. One consequence of that is dire poverty. The Human Development Index rankings just came out this week, and Haiti is 163 of 188. And the other 25 countries that are behind Haiti are all in sub-Saharan Africa and Asia. Nowhere in the hemisphere is even close. Haiti also has an unnatural vulnerability to natural disasters. Everybody knows about the 2010 earthquake and last fall's Hurricane Matthew, and you're going to continue to have natural disasters in Haiti that pay a heavy toll just because there's no resilience within the government structures. All these problems generate migration. The U.S. is the largest destination for Haitian migrants, but there's also many have been going for decades to the Dominican Republic. Many go to the Bahamas and other countries in the Caribbean. And one of the routes that has helped generate this deportation crisis is Haitians going to Brazil. In terms of the law enforcement, the Haitian National Police, Haiti's army always did all the police functions up until 1995 when Haiti put in a national police system, and that system it's been up for 22 years. It's been decimated by coups d'etats and politicization. It's never been funded adequately, and there's never been adequate training. There are many good officers, but there's also many corrupt and brutal officers, and they're often overwhelmed. Just this picture of this guy, and I'm not sure if you can see, he's got sweat coming down his face. This was a couple of years ago. He was outside a courtroom, and he was trying to restore order. And they were doing a good job of restoring order in the courtyard, but what they had not been able to do was to stop thugs associated with a government official disrupting a rape trial that had happened earlier in the day. And that's, I think, symbolic of the Haitian police. They're just not able to protect people and to deal with organized efforts to harm people. The justice system has adapted for 300 years to whoever had the guns and the money. It's poorly financed. It's highly corrupt. I mean, almost every prosecutor and judge does some things that we would define as corruption in the United States. And there's a huge pretrial detention problem. 80 to 90% of people in Haitian prisons have not been convicted of a crime. The justice system is not effective as a deterrent for attacks against individuals. Haiti also has a problem with, so the first slide is the Palais de Justice, the main courthouse, which was completely knocked over during the earthquake. The one in the bottom right is the new Court of Appeals, or the Supreme Court building, which shows there are efforts to get the justice system back up. And over the 20 years I've been working on Haiti, the justice system has made some pretty significant improvements, but it is still basically corrupt and poorly functioning. Haiti has a problem with gangs. The gangs are outgunning the police, and they've often either infiltrated or allied with the police. And I'm seeing lots of cases, both in Haiti and asylum cases, of people who are attacked by gangs, and then the police are not an effective deterrent, or it's not an effective place they can go for protection, in part because you have a lot of joint, especially on kidnapping, you have joint police gang operations. And you also have, in some cases, you have police allying with one gang against another gang. The next slide is the politics. So Haiti's current political situation is, there have been several years of an electoral crisis where you never had a fully sitting parliament and executive branch for about 5 years. Now that's been resolved. You have, starting in February, a new president was inaugurated. You have a full complement in parliament, and so that has settled down a little bit. But there are concerns about the existing government. The president is Jovenel Moise. He's from the PHTK party, which is a party started by former President Michel Martelly. And one of the concerns that people have is that that Moise is probably going to continue some of the same policies of President Martelly. Many of them involved human rights violations. Nicole will talk a little bit about attacks against the press. One recent attack happened on a week ago Monday, where former President Jean-Bertrand Aristide was summoned to court. Most legal experts agree he wasn't summoned for a good reason, that it was probably some kind of harassment. But on the way back, his motorcade was shot at. A couple bullets hit his car. One bullet hit one of the security guards, and some other people were hurt. The police did not step up and immediately try to do an investigation, as far as we can tell. And many of President Aristide's supporters say that the police were actually doing the shooting, and there's some videos to back that up. Another issue with the Moise regime, again, 2 months, less than 2 months, a little bit early to tell anything for sure, but Parliament did vote a very dangerous defamation law that Nicole will discuss. And maybe I'll pass it off to Nicole, who she's been working on the ground in Haiti on a case that I think brings together a lot of the strands of political violence in Haiti.
Thank you, Brian. Right, so this case that I'll mention happened in a small town in the south of the country, but I think is emblematic of certain elements of a case that could happen just easily in Port-au-Prince. This was a mayor who used terror and violence to rule this small town. It was a 2-day drive from Port-au-Prince, so it was quite isolated. In 2007, the mayor put together and accompanied a group of about a dozen what he partisans or henchmen that were armed with machetes, sticks, guns, and they publicly lynched a 21-year-old kid just because the kid's brother had crossed him earlier that day. There was no other real vengeance. A year later, in 2008, the mayor organized the same henchmen to destroy a local radio station that he perceived as opposing him. He ordered the shooting of 2 of the individuals involved, leaving them disabled. A year later, 2009, this same mayor then ordered 36 homes to be burned down of his, again, perceived political opponents. He was living in the United States at the time. So this shows the network that he had still in Haiti to be able to order this type of crime. The victims have done everything they could think of to stop this man and receive justice over the last 10 years. But the justice system has not worked for them. Frequently because in this case, it was either individuals involved were in alliance with the mayor's political organization, or lacked the political will to get involved, or were just too afraid. And so these clients incidentally filed a case under the Victims Protection Act in Boston last week with the help of the Center for Justice and Accountability. And a day after the mayor was served, last Friday, one of the plaintiffs in the case died under suspicious circumstances. The family and the community think that the mayor was killed through either voodoo and or poisoning. So this is slightly exaggerated case, but I think it does bring up a few elements that are at play in a lot of these political cases, which is violence by often is a low-level government agent against someone they perceive to be a political opponent. There is an abuse of power, no oversight of accountability, and there's often this mixture that you might see in your cases of mixture of personal vengeance with them as well. And the defamation law that Brian mentioned, Haiti already criminalized defamation, which is illegal, as we know, under international principles. And so this defamation law will only expand those criminal penalties, and I think really sends a message out to journalists that the government is not in supportive of their work, and that they should be fearful of their work. And I can talk a little bit more about the press in a second. Switching over to some other particular categories of cases that we've seen. One is gender-based violence, and when we talk about gender-based violence, it could be it's often violence plus sexual assault. It could be domestic violence related or non-domestic violence related. After the earthquake in January 2010, we saw an increase in stranger rapes and gang rapes. I'm aware of many of these women have sought to leave Haiti or did leave for fear of retaliation. So these are some cases you may see. Rape has been used as a form of political violence in the past to silence Haitians, particularly under the 2004 coup. I'm not seeing that many cases like that right now, but it's always something that could come up. In terms of gender-based violence with LGBTI cases, there also are reported cases of lesbians in particular being raped either by strangers. When I say strangers, I don't necessarily mean strangers. It could be people they know, but it's not a domestic violence situation. So it could either be by that or by their partners or husbands who found out that they're gay. A lack of infrastructure and resources make it very difficult for women and LGBT people to find justice. There are very few, if any, shelters or social services available to them. Many of them, if any, do exist. Some grassroots women's organizations are available to offer some counseling, etc. But many of those are located in the capital, and so they're largely unavailable in the provinces outside of the capital. Victims also will face stigmatization from their families and the communities, and also they'll face a weak legal system, as Brian mentioned earlier. The stigmatization is really important, something you might hear about. In Haiti, people survive. People without means, economic means, survive based on your neighbors and your community. And so when you don't have enough to eat that day, then you survive on your neighbors to give you food or help you if somebody is sick. So you don't want to ostracize your community. That makes a lot of people fearful and not able to get resources, or fearful of reporting it as well. Police, prosecutors, judges, all often have used discrimination against women and LGBT people. It's very, very difficult to get a response from the legal system when you are a victim of violence. You would need an attorney. With an attorney, there is more of a possibility to work through the system, but of course attorneys are almost impossible to retain because of money and other issues. Retaliation is a serious, serious threat. It could be from the perpetrator itself or the family of the perpetrator who don't want to lose their breadwinner or be stigmatized, have their reputation stigmatized in the community either. So the victim faces those extra threats. A few particular instances with LGBT. Haiti is a very Christian country. There's a lot of homophobia from the top down, from parliamentary level to in the slums. Even educated lawyers and judges often don't seem to really understand the need for equality, including LGBT people. So stigma is huge. Many hide their identity out of fear from being cut off from their family, which they may depend on their family for housing, food, security. It's difficult to find jobs. And many marry the opposite sex anyways for security, especially women. And as I mentioned, lesbians face violence. The last thing I'll talk about is press. I would add human rights defenders in with press. I think they're treated quite similarly and they face very similar obstacles in Haiti. The press is very underfunded and undertrained in Haiti. And so as a result, the government and other powerful private actors can easily buy journalists or scare them through threats or violence. Some taboo topics are drug trafficking, corruption, crime allegations against somebody in power. Again, that could be private sector or that could be government. Violence does occur, threats of violence do occur. It's not as pervasive as you would see in other countries like Honduras, but there seems to be targeted threats of violence and occasional killings, which are rarely investigated or punished, and creates a strong climate of fear among both human rights defenders and the press, journalists. Murders tend to be made to look like a robbery or a natural death, but the community, everyone sort of knows, and there's rumors, but again, there's no police investigation, so the truth is never found. Many journalists and human rights defenders restrict their activities to only going to work and home. They often don't go out to restaurants, don't go to the store to buy food, those kinds of things. They feel so endangered that their social lives are quite limited through self means. And those without any economic means, and again, journalists tend to be very underfunded, are particularly vulnerable. There's no real system of safety or government protection.
Nicole, before we move to the next one, I just wanted to remind all speakers to mute their phones when they're not speaking. We've heard that there's some background noise. Thank you.
And I will turn this over back to Brian to talk about the next categories.
Thanks, Nicole. I'd like to talk about two more categories. One, it's not on this slide, but it's police officers. We've been seeing a lot of police officers seeking asylum, and their claims are usually based on them being whistleblowers, either going after a gang they weren't supposed to, or somehow opposing police being involved in criminal activities. And there's been plenty of attacks, documented attacks against police in Haiti. The most notorious example is a guy named Waki Calixte who pulled over a car with security guards from some members of the House of Deputies, and one of them had an illegal gun, and the police officer took the gun and took the guy and brought him to the police station. Later that day, a gang went through the town and hunted this guy down, Waki Calixte down, and killed him. Over the next year, they shot 3 more of his squad members, killing 2 of them. And it took years. The case is still, I believe it's still going through the court, but for months there wasn't an arrest, and it took a couple of years even to arrest these people, even though everyone knew who was doing it. Another issue that we see coming up a lot is land conflicts, and the foundations of the land conflict problem are the fact that Haiti does not have a good system for registering land. Add on to that the history of coups d'etats where people have used political power to get either something looking like an official title or possession of the land. And so for any particular piece of property, it's often very difficult to figure out with any legal certainty who owns it. And that just opens it up for people to come in and take it. And some of them are purely private takeovers where people will use individual violence, individual threats of violence as a way of getting people to either give up their claims or to vacate their land. But often the government is brought in, either police or judges, and you have some kind of official title, and the police are actually evicting people. In some of these cases over the history of Haiti, you've had some bloody massacres where hundreds of people have been killed as a result of these land conflicts. They seem to be, I haven't seen anybody who kept statistics on the numbers, but they definitely seem to be escalating over the last 5 to 10 years. The last thing that I'd like to talk about is resettlement. We get, in a lot of cases, people asking about whether somebody can just resettle within Haiti. And our analysis is that's difficult to do. Haiti's what's called by sociologists a high context society. As Nicole explained, you really need your social connections to get a meal, to get a job, to find adequate housing. And as a result, it's very rare for somebody to just pick up and go to a new place. And if they do it, it's very hard to live unless they have substantial independent means, and they don't need the network to survive, which most victims of violence don't have that. And the second issue is, even if they are somehow able to do that, that's going to get everybody's antennas up. If someone moves into your neighborhood, and the first thing that you're going to do is you're going to talk to them and try to figure out where they fit, where their social network is, and where that intersects with you. And if they're resisting giving you that information, you're going to keep trying, you're going to keep looking. And I think through that, people will end up getting, you kind of turn all your neighbors into detectives, and they're going to eventually find out what you're hiding from. And so in our case, we find it difficult. One example, this is a little bit old, this was in 2004, we had a client with his son who had to leave, and we were able to get them some support, some money support to leave for a while, but that was limited, and he was just not able to, where he went, he was just not able to get any money to eat or to get food. He didn't have a network. And in 2005, after a year on the run, he called our office in Haiti and said, I'm going back. And our office explained to him what they thought were the risks. And he said, well, I've got a choice between a high risk of political violence back home or a certain risk of dying of hunger and my kid dying of hunger in Haiti. He went back, and a few months later, he was killed. So it's the kind of risks that people are running with resettlement. I think that's it for our presentation. I would encourage, as Steve did, for everybody to look at the Haiti Asylum Information Project. Most of the issues we've addressed are addressed in more depth on the site. I'd also encourage people to look at the State Department Human Rights Report for 2016. Over the years, we've been critical of the State Department reports as being highly politicized, but this one is actually fairly good. There's, I think, some of the issues like around elections, there's some politicization, but it's you'll find it useful in a whole range of asylum cases.
Great, thank you so much, Brian. So I'll now turn it over to Steve, who will first address best practices for working with Haitian asylum seekers, and then on to Clara. So, Steve?
Thanks very much, Blaine. And Brian, regarding the living in other places, in addition to all the factors you mentioned, Haiti is also a small country, and as you say, persons are going to stick out sort of like a sore thumb, and it may very well come to the attention of whoever they're fleeing from, where they are. So it's not so easy to hide somewhere else in Haiti. So deportation to Haiti can be, of course, a question of life or death, not only due to the repression and lack of the rule of law that has been mentioned already, but given some of the direst economic conditions in the world, an unchecked cholera epidemic, increasing deaths from malnutrition due to Hurricane Matthew-related food insecurity, etc. Interviewing Haitians can be very challenging. Haiti was for decades a kleptocracy, government by thieves from the highest to the lowest levels. Interactions with authority figures were fraught with uncertainty and danger, and often still are. Regular people could be and were attacked, extorted, raped, abused, their land or goods taken, their relatives victimized, if they said the wrong thing to any more powerful person. Staying safe meant not challenging authority, not making waves, trying to figure out in any encounter with a more powerful person the expected or right answer to any question so as to stay safe. You and your interpreters, you now as an attorney and your interpreter, are authority figures. So your client may be wary of you. Sensitivity to this is especially important for your interpreter, and you should instruct your interpreter accordingly. For all your client knows, your interpreter goes back and forth to Haiti and may be in touch with authority figures there. Your client may clam up about abuses they suffered and not want to tell you about them for fear of retribution against family members back in Haiti, should word get back there that your client talked. What this means is that establishing trust in the interview is hugely important in the Haitian context. Your client needs not only to hear, but to believe that everything they say will stay confidential. You need to sensitize your interpreter to this and take time for both of you to establish some kind of sympathy and rapport with the client. Say something about yourselves. Show interest by asking sympathetic questions about how your client's doing at the beginning. And through your demeanor, patience, and kindness, encourage your client to feel comfortable with both of you. Explain the asylum process and stress how important it is for your client to tell the truth. I used to ask, what did you do in Haiti? If the person said, I farmed, I'd say, I've never been a farmer. So if I need advice on farming, I'd come to you and ask your advice. And then I'd ask, have you ever been an attorney? When they, in most cases, of course, somewhat surprised, say no, I'd say, well, I'm an attorney. It's my job to know about this process. I'll do all I can to defend you and help you try to win your case. You can stay in the U.S., but I hope you'll consider what I'm going to tell you from my own experience as an attorney. I'd say to have the best chance to win, I'd say to the client, it's important to tell me the truth about what happened to you in Haiti, not for any religious reason. I'm not a priest, but because you simply won't be able to remember the details of your story later on at the hearing in front of the judge unless it's true. No one can remember the details of a lie. We're going to put down in your asylum application what you tell me, and the judge and the government will have that application in front of them when you testify in your hearing months from now. They're going to be comparing that application with what you say then at the hearing. And they're probably going to ask you hard questions to try to trip you up to see if you're telling the truth. And if your testimony at the hearing is different from what's in the application, what we're going to give them soon, the judge may not believe you and deny asylum because of that, because they find you not credible. I try to get through to the client that no one, no matter how smart, me included, can remember a lie. And I also tell them that I'll never be mad at them that they should always feel free to change and correct anything they told me before to make sure I've got the true story. Stress similarly that it's essential not to exaggerate anything. The judge is trained at listening closely to determine if someone is telling the truth or not, I tell them, and an exaggeration may come back to haunt them. Just the facts. Let your client know that there is no right or wrong answer to anything you might ask them, that they should just tell you whatever really happened. Have the interpreter only translate exactly what the client says, even if it's not responsive. If you ask, for example, how old are you? And the client answers, I was a farmer. You want your interpreter not to remonstrate with the client, but just to say in English to you, I was a farmer. It's for you, of course, to ask a clarifying follow-up. Your interpreter shouldn't inject themselves and should just translate in the first person. For example, I was a farmer, not he says he was a farmer. Importantly, use what I call phrase-by-phrase translation. Tell your client you want to hear everything, but that since you don't understand Creole, you need them to answer one phrase at a time so that the interpreter has a chance to translate it for you right away into English. Most often, your client won't get that and may start talking rapidly in run-on sentences, not giving your interpreter a chance. If so, a lot of their story you're never going to hear. It'll be lost or it'll be translated inaccurately, simply because no translator can reliably remember more than a phrase or sentence at a time. And it's so important. I mean, the translator's job is so crucially important and that you get everything, because otherwise, of course, the asylum claim can be denied because later on the testimony is slightly different, doesn't include everything, or is inaccurate. So practice the technique of phrase-by-phrase translation beforehand. If your client runs on, the interpreter should gently stop them from doing so by putting up a hand gently in a stop sign motion and or saying something like, rete, wait, after each phrase or sentence, and then translate it into English for you. When the translator's done doing that, they can signal your client to continue. But when you have your interpreter do this, it takes a little bit of practice, but it's really worth it. The interview will start to flow beautifully. You'll get what your client is saying accurately and fully without omissions of perhaps key parts of the asylum story, resulting, of course, from the translator simply being unable to remember an entire paragraph of stuff in Creole. And you'll also be building trust and confidence because your client will see that you care enough to be doing this right, and your client will start pausing themselves to ask the interpreter to translate what they just said for you into English. Something else, you can't just ask your client what happened to you in Haiti and expect to get anywhere near the full story. Your client, who grew up in a completely different society and culture, doesn't know that specificity is needed to win asylum and won't usually provide you with the details you need. So be creative and ask lots and lots of questions to elicit your client's story and life, which you want to understand inside out. As an example, in just one area, to rebut the assumptions that your client left Haiti for economic reasons, you can ask, where did you live? What did you do for a living? Were you married? Children? How much money did you make? Did your spouse work? How much did they make? Did you have people working for you? If so, how much did you pay them? Did you have savings? How much? Did you own any land? How big? How much? How big was your house? Bigger than most? How many rooms, bedrooms? Did you have a television, furniture, etc.? How did you compare your quality of life in Haiti with your neighbors? Were you poor, better off than most, getting by all right? Did you leave for economic reasons? Would you have left Haiti if it had not been for the problems you're telling me about? Did you want to leave Haiti, the country presumably your client loves, etc.? And why all these questions about economics? The example I'm giving, because lurking in the background, as you know, of every Haitian asylum claim is the implicit or explicit assumption by the government that your client is just another Haitian who came here to work. In contrast, and the reason I ask about economic stuff and everything else is you want your client to stand out as an individual who really had, ideally, no economic, but only asylum-based reasons for fleeing. The same thoroughness in asking lots and lots of questions, which is really necessary, applies to, of course, what happened to your client. Don't just ask if they ever had any political problems. They may not understand the word political, but that doesn't by any means mean that they didn't have such problems. And you'll often want to repeat the same question different ways to verify that you've got the story right. Did you have any problem in Haiti? What happened exactly? Who'd you have trouble with? What's his or her name? Who were they exactly? How old were they? What's his position in the community? Was he powerful, abusive? Did he ever threaten you? How many times? What did he say or do to threaten you? Did he ever threaten any of your family members? How? What did they do? How often? When? Get details on each incident. Had he ever abused, attacked, killed, or stolen from anyone else? What happened to them? Had you had problems with him ever before? What happened that time? Did you have any trouble with any other powerful persons? Ever been abused by anyone previously, etc.? You need to ask lots of questions to dig out the details of everything relevant to your client's fears and their reasonableness, and then to verify that what you've got is correct. And you may need to do this many times. And also when you read back their story to them at the end of the process, when you think you've got it, and you read it back to them to make sure you've got it all correctly, you want to do that very slowly, phrase by phrase, with a lot of pauses to give your client a chance to correct any errors as you go along, because they're not going to remember to do it later. So before starting to read it back, ask your client to immediately, insist on it, that they immediately interrupt you. And please interrupt you to correct anything that's not exactly right. Again, if you wait till the end, they just won't remember to make the correction. A detail about chronology. To establish sequence of events, use before and after. Don't trust dates. Haitians, in my experience, aren't good with dates very often. So you can ask, did X event happen before Y event or after it, et cetera, et cetera. And even that, you've got to really be careful and double and triple check the chronology. Specific dates can be very unreliable. So check any dates or year that's mentioned very, very carefully and do so again later on. Apply the same thoroughness to
Steve, I just wanted to give you a time check to let you know that we have sort of where we are in terms of getting to Clara about 7 minutes or so left of this subject. So thank you.
All right. So the same thoroughness to the sworn statements, all kinds of questions. Was it read back? Was a competent Creole translator used? Did you say things, what happened to you in Haiti that aren't here in the statement? Were you rushed? Was the translator sympathetic, et cetera, et cetera? I'm really wrapping up. You need to be kind of like a prosecutor, a kind one, of course, gently cross-examining your client, both to elicit the story in the first place and then to make sure you got it right. Tell them,
Well, I think we may have lost Steve. While we're waiting for Steve to come back, Clara, I think we can pass it to you.
Yes, let me move on quickly. I know we're running out of time. My name is Clara Syria. I have been representing Haitian asylum seekers for many decades in Miami, and so I'm glad to be able to share some of my experience with you. As you can tell from Steve's excellent presentation, knowing your Haitian asylum client is important. My presentation will reinforce much of what Steve said, but I will also touch on some of the culturally specific things to look for, especially when it comes to this new population of Haitian asylum seekers that's coming through Mexico and other places. One of the things that Steve talked about, interpretation, is really important. The interpreter should be your friend, and his interpreter is part of your team. There are some interpreters, however, even though the standard for interpretation has really improved over the years because of more claims coming through, some interpreters are still unfamiliar with certain terms, certain names and concepts, and they might be a bit reticent to admit their lack of knowledge about these things. So it's important to let your interpreter know that you respect and value their interpretation skills, that even the best interpreters can encounter unfamiliar terms, but importantly to let you know if they encounter such a term, because those terms can be key to your claim. Some client makes a claim about what they call chimeras or other terms that they use in Haiti, the terms of art. If that person is not familiar with it, they may translate it to something else, and you may totally lose the context. So look out for that. As it relates to the content of the asylum application, repetition works very well with Haitians. So going over the claim many times really helps. But it is also important to emphasize that the asylum statement, even a very detailed one, is not to be memorized and recited, but that the person must be able to respond to any questions about the claim, even if taken out of order. So Haitians are used to having their asylum statement translated to Creole for them, and this could be very helpful. But please remind them against rote memorization. Okay, Steve talked about the context of the claim. One of the things that you kind of need to do in many cases is to teach your client about Haitian politics. Because even those who are active in politics may not know the details of the Haitian political scene that informs their claim. Judges expect asylum applicants to know the basics about dates of major elections, the dates of presidential terms, and the major political fights during the relevant periods of their claim. Failing this test can doom an otherwise good claim. So once you are up to speed on the major political events in Haiti, test your client's knowledge, and if necessary, give the client a summary with relevant names, parties, and dates. This can be very helpful. You can give them a little chart because for many judges, this is an important litmus test, and passing it can really help your client. Steve talked about establishing trust and encouraging people to tell the truth. Truth is an important thing when it comes to Haitian claims because some Haitians have difficulty in terms of expressing what they think is the truth. Some Haitians think, for example, that they must continue to repeat statements that were made on the record, even if it was a misstatement. When people come in, they're often subjected to many different interviews, and so they may say something, initially at first, and many of them think that they must continue to repeat that statement. For example, if they mistakenly said they were married or they had children who were not legally theirs because they were maybe the brother's children, but they grew up with them, they thought it was theirs, and they learned that it's not theirs, at least not in the eyes of the American official, they will likely continue to repeat those assertions unless you identify the problem and explain the need to correct the record. So many Haitians also tend to repeat what a smuggler, a family member, or fellow immigrant tells them about what to say to immigration officials. A classic example involves whether the person had persecution or other problems. In the past few years, it was common for those who denied having problems to get released more quickly from ICE detention. And people were encouraged to say that they had no problems so they could be released faster. This led not only to expedited removal for lack of credible fear, but to credibility issues for those who later amended their claims. So it's good to ask people about what others may have told them to say. And there's also an issue about past representation. Not only have many of the recent arrivals traveled to many countries, but many had tried to get U.S. visas to leave Haiti. A common problem in those cases is that the people who helped them with the visa applications often indicated that these people were married and they had filed fraudulent marriage licenses on their behalf. So it is important to ask the clients in many of these instances about any past visa applications they may have submitted, because the representations that they made in those applications can come back to haunt them, because because not only does it create an issue of fraud, but also the timing and the mere existence of a past visa application can undermine an asylum claim. If the person claims something to be happening at the time, and it turns out it conflicts, well, they also apply for a visa at the same time, that can create problems. Another issue is supporting documentation. Haitians often present documentation which they have never read or previously seen. It is common for them to simply have family request documents from Haiti, and they simply trust that the mere presence of these documents will do the trick without considering potential content inconsistencies or that the document might have been procured fraudulently. The documents typically come in with little or no indication of chain of custody. So, especially in light of the Real ID Act of 2005, which mandates the presentation of available documents and the severe consequences of a frivolous finding, it is important to get the client to have someone read the documents that they're presenting for accuracy and consistency before turning it over to their representative, and also for them to be able to verify that the document was produced from the source which he claims to have come from. Okay, there are certain special issues regarding to documentation as it relates to marriage and birth certificates. You will find many Haitians that have birth certificates that were filed late. The person may have been born in 1960, but they come with a locally registered birth certificate that was registered in 2006. And American officials do not trust these documents. They often indicate fraud, even though a lot of people say, well, because of the earthquake, they lost the documents. But this is a starting place where to look at information on that, because fraudulent documents create big problems. You could even have a birth certificate that says that in 2006, the person's father came and declared the birth of the person, and whereas the person's father may have died many years ago. So I know we're short on time, so that's most of what I had in terms of additional information from what Steve had given, and so I'll be glad to take questions later.
Thank you so much, Clara. I'll pass it back to Steve, who I believe is back with us for his final remarks, and there will be an opportunity for questions at the end. So thank you to those who've already sent them.
Thanks very much. I was saying, I think when I cut off, that the attorney needs to be kind of like a prosecutor, a kind one in interviewing your client, but gently cross-examining your client, not only to elicit the story in the first place, but to make sure that you got it right. You can tell them that while you're going to fight with all your might for them, but that the way the system is set up, the opposing attorney is going to try to poke holes in their story to convince the judge that what they're saying isn't true. That's going to happen at the hearing. So you need to play devil's advocate now in your interview and in your preparation later to prepare your client for that and to clarify misunderstandings and correct them before you put it into your asylum application, before you put in there possibly damning errors, which frequently occur inadvertently due to translation issues, cultural misunderstanding, memory factors. If you don't painstakingly double and triple check with your client that you've got the facts and the chronology straight, inevitably, you'll definitely get some facts, details, and or chronology incorrectly on your first or second go-round with the client. To familiarize yourself with political and social conditions in Haiti before you begin interviewing is of course important, because it'll give you a better sense, as hopefully this webinar will do, of the kinds of questions you need to ask your client. And I can't stress enough, you need to really dig with creative and imaginative questions to get at everything that might have happened. And the Haiti Asylum Information Project webpage is one way to try to familiarize yourself. Lastly, Blaine reminds me, and I'd welcome any further comments from her on any aspects of cultural concerns, that Haitian women are often very reluctant to disclose humiliating abuse in the context of a border interview, and that there's good case law and documentation on this. Similarly, if your client is a Haitian woman, just in general, great sensitivity is required from both you and the interpreter so that your client will feel comfortable sharing any sensitive facts, and no need to try to get at any such intimate or sensitive information with both persistence and, of course, tremendous sensitivity. So thanks very much.
Great, thank you so much, Steve. So now that you understand the background country conditions and you've used these best practices to really obtain a full context for your client's story, how do you prove that these claims fit into the asylum eligibility framework? So I'd like to turn it over now to Debbie Anker to walk us through that and some key theories, legal theories for the types of claims that we've heard about. Debbie?
Hi, should I move between slides? I didn't know. Or you do that, or?
Thanks, Debbie. I'll take care of that.
Okay.
If I'm on the wrong slide, just let me know.
Okay. The U.S. law governing asylum eligibility is based on an international treaty, the Refugee Convention of 1951, which the U.S. became a party to in 1967. And Article 1 of that treaty defines a refugee, and this definition has now been, with some changes, but basic incorporation of the definition. And that definition contains the criteria for eligibility for asylum protection in the United States. So the definition of refugee that is in U.S. law is contained in INA section 101A42. And it defines a refugee who's eligible for asylum protection as someone who has experienced past persecution in the past or has a well-founded fear of persecution for reasons of race, religion, nationality, membership in a particular social group, or political opinion. So to establish eligibility for asylum, it's important to think about each of these elements and think about them distinctly when you're proving your claim. So it's past or a well-founded fear, that's the first element. Of persecution, that's the second element. On account of, that's the third element. That's the causation element. And then the grounds, race, religion, nationality, membership of a particular social group or political opinion. And then lastly, that there are no ineligibility bars that apply, and I know that Blaine is going to talk about one major ineligibility basis, firm resettlement. For proving past persecution, so this is important, and it's actually a difference in U.S. law from international law. Past persecution can be enough to establish to make a person eligible for asylum. Under the regulations, past persecution creates a presumption of a well-founded fear, and where the applicant establishes that he or she has been persecuted in the past, again, for one of the 5 reasons, then the burden shifts to the government, and it must prove that you don't have a well-founded fear of persecution. And again, the regulations provide that the government can establish that by proving fundamental change in circumstances, either in the country of persecution, or that the person has internally relocated, and that that internal relocation, the person can internally relocate, and it's both possible for that to happen and reasonable, and we can talk about that in the context of well-founded fear, since it's an element there also. If the government, and I would say the government probably was going to have a very hard time proving a fundamental change in circumstances in Haiti, or that internal relocation is possible and reasonable. So in many of these cases, I would expect in the Haitian context, if you do a good job, you're going to not face that challenge. But there are circumstances in which even if the government proves a fundamental change in circumstances or that internal relocation is possible, you can obtain asylum protection based on past persecution only. That's a discretionary basis for grant of asylum. and you have to show compelling reasons arising out of the severity of past persecution, or that there's a reasonable possibility of other serious harm. And that other serious harm does not have the on account of element. It just has to be proving other serious harm. It does not have to be for reasons of one of the 5 grounds, and those can be substantial human rights violations and extreme hardship, really, in the country if they're returned. And I think that would also be something that, you know, that would be, if you do a good job, you could prove in Haitian cases based on what we've already heard. There were other related protections. I mean, I mentioned withholding of removal. There's also Convention against torture. There are other non-treaty-based protections that are available to people, but I'm not going to talk about them now. Okay, I'm ready for the next slide. So the fear must be, in well-founded fear cases, the fear must be subjectively genuine or subjectively genuine and objectively reasonable, and that's sort of the classic matter of Mogurabi case, which I cited up there. And types of proof, testimony that is credible, persuasive, and specific is really the centerpiece to establishing eligibility for asylum. And Steve has talked about some of the challenges in representing Haitians and the use of interpreters. I won't go into that, but testimony is really critical, the critical centerpiece of an asylum claim. Also, asylum claims can be, types of proof include proof of human rights conditions in the country of origin. I think it was Brian who mentioned the State Department report. Many of the cases have held that the State Department reports are to be given a special weight, although the regulations also provide that, for example, for asylum officers, that they're to consider country condition documentation from other credible sources. People also use, I know in our cases, we regularly use the testimony, the affidavits of experts. Brian will be very busy. And often that can provide general country condition evidence. It can also be specifically tailored to and respond to the specific circumstances of your case. You also can provide case-specific documentation, identity documentation, and we could talk about that more during question and answer. I think Steve referenced, or somebody referenced the requirement in the Real ID Act of 2005 that you have to present all evidence that's reasonably available. Okay, I'm sorry. I
think that you've got 5 more minutes.
5 more minutes. Okay, so showing past persecution and past harm, targeting of an individual, or targeting people closely associated with them. Threats can be a basis. Showing a pattern and practice of persecution of similarly situated people, and also the claims can be recognized, but the post-flight sort of claims can be recognized, where somebody's claim is based on, say, political statements they've made about the situation in Haiti while they're in the United States. I won't talk about internal flight too much. We've talked about it. I think this is something that also should be readily able to be proven. Haiti's a small country, and kingship ties that follow individuals if they attempt to relocate. Brian and others have talked about that. Could you skip to the slide that says nexus? I'm sorry, those are out of order. So, I'm sorry, no, persecution first before nexus. So persecution is commonly understood to be constituted by 2 elements: serious harm and a failure of state protection. And this is really important because this means that a non-state actor can be the agent of persecution. The government doesn't have to be the agent of harm as long as it's failing to protect. And I think that can be established in in many cases. So it could be a gang member, it could be somebody who claims rights to your land. It could certainly be a domestic partner. And there's a list here of what some of these forms of harm. Discrimination can be severe. You know, somebody referenced social life being limited in the case of someone who was an opponent of the government or a journalist. That might be the kind of harm, that social isolation might be the kind of harm that establishes persecution. Economic rights and land ownership. When I was looking this over in my book, there's actually some very helpful case law. There's a case called Vincent v. Holder, 632 F. 3rd 351, where the court found that large-scale confiscation of property may amount to persecution, even though the applicant could otherwise survive. There's a board case, matter of TZ at 24 INN 163, where the wholesale seizure of assets of the family may be so severe as to amount to persecution. And there's quite a few other cases where deprivation of land or property constitutes persecution. Now the nexus slide. So in addition to showing persecution or well-founded fear of persecution, you have to show that there's a nexus to one of the 5 grounds. So the past or feared persecution must be on account of one of the enumerated grounds. The most important thing to remember about nexus is that you can establish nexus even in cases where there are mixed motives. There may be political motives, there may be motives related to your particular social group, but as long as that reason, one of the 5 protected grounds, is at least one central reason for persecuting the applicant, you've established nexus. So the case law very strongly recognizes, although often the adjudicators don't practice, this recognition of mixed motive. Now, the grounds. Talk about particular social group. I know I only have a few more minutes. So particular social group is defined as a common characteristic that cannot or should not be changed. An immutable characteristic such as sex, color, or kinship, a past shared experience, and this is directly from the foundational case of asylum law from the Board of Immigration Appeals, the matter of Acosta, which mentions such as formal military leadership or land ownership. So land ownership has been specifically recognized by the board as a characteristic that can meet the criteria of the particular social group ground, or something that is so fundamental to their identity or consciousness that ought not to be required or changed. The board has subsequent to matter of Acosta added 2 other criteria, social distinction and particularity. Those have been challenged in a lot of court decisions. Social distinction is perceived in the group is perceived in society as socially distinct. That might also be something that you can prove in a Haitian case where land ownership cases in particular, where that is such an important marker in Haitian society. Particularity, which has been really is problematic and unclear, and anyway, it was even critiqued by the Department of Homeland Security in the case that they appealed, but it means that the group should not be amorphous or overly general. Here, the particular social group grounds in the Haitian context that have been, that are relevant, and we already talked about why they would be relevant. Gender or domestic violence was recognized in the case of matter of ARCG, married women who cannot leave the relationship, and there have been some unpublished cases that have recognized that applies also to unmarried women. LGBT cases, HIV, mental disability, family membership, which is so important in Haitian cases, has been well established as constituting a particular social group, and matter of H is the classic cases. I would say based on what I'm hearing today, a former police officer, a journalist, and remember that former status, formerly being a landowner, having been displaced, arguably could meet the criteria of the particular social group ground. The next is, and I'm just highlighting really the particular social group and the political opinion ground. Political opinion has been recognized as not just party membership. It's not something that is just the domain of the elites, but this is a quote from a classic quote: "The instinctive or spontaneous reaction to oppression is equally valid as the educated opinion." So people who express an opinion by resisting, refusing extortion, refusing to join a gang in some of the Central American cases, this can be an expression of a political opinion and evidence of a political opinion. Examples in the Haitian cases, there's one of the classic cases of in asylum law, Desir versus Ilchert, which this was in Duvalier, Haiti, where a Haitian man who refused extortion by the Tantan Makouts, who were threatening his very livelihood, was imputed with an anti-government imputed political opinion. And the political opinion was recognized in that case. And they specifically talked about Duvalier, Haiti, being described as a kleptocracy. Political protests, corruption, exposing corruption in government, journalists, opposition to gangs or forced recruitment. I don't know how much that is a country condition in Haiti. We didn't really talk about it, but these have been recognized in some of the Central American gang cases. I would say the Central American gang cases are very much in flux, both in terms of the particular social group ground and the political opinion, but I think that they're moving in a positive direction in the federal courts. Land ownership is a ground, political opinion, citizens opposing government eminent domain policies by protesting state expropriation of land. I think somebody already talked about the 2013 protest in Jeremy. The land ownership has been recognized as a PSG. I mentioned the matter of Acosta. There's also an excellent Seventh Circuit case that you have up there, Tapiero versus Orihelo. You know, internally displaced landowners or claimants, which I mentioned already, whose land is built upon by others. Particularity might be a challenge since the group is very broad, but all the other grounds in the asylum definition are broad, and you know, race is very large and nationality is very large. That's why I think the particularity requirement is not really appropriate. I'm going to end there, but I'm going to just want to mention one other thing that I forgot to mention. If you go back to persecution, the very first case of recognizing gender violence was a Haitian case. The case is called Matter of DV. I don't have it in the materials. It's at 21 INN Decision 77 in 1993. This is right after the first coup against President Aristide, and security agents of the government came into people's homes. Men had often fled, the women were left, and there was a case of rape of a woman who had Aristide posters in her house, and having the Aristide posters in her house was considered an expression of political opinion, and the rape was considered grievous harm that amounted to persecution. So that might be an important one to keep in mind, just because you can cite a case that actually involves Haiti. So that's it for me. Thank you.
Great, thanks so much, Debbie. So I know that we are running out of time, so I'll try to blow through the firm resettlement bar to asylum relatively quickly and just let you know that we are working with the Brazilian immigration attorney to develop a declaration that will address some of these issues for individuals, and we appreciate any information that you can share with us. And I see some questions coming in, and we'll try to get to those as soon as we're through. So thank you. So firm resettlement is a mandatory bar to asylum under the statute, regulations, and interpretive case law. Notably, the firm resettlement bar does not apply to withholding of removal or Convention Against Torture claims that Debbie mentioned. So what does it mean for someone who traveled through a third country like Brazil, for somebody who's coming to the United States to be considered firmly resettled? According to the federal regulations, an applicant is considered to be firmly resettled if prior to arriving here in the U.S., he or she entered into a third country with or while in that country received an offer of permanent resident status, citizenship, or some other type of permanent settlement. Broken down, this includes three key elements. One, entry to the third country. Two, an offer. And three, an offer of permanent status. An applicant may be considered to have received an offer if he or she was entitled to permanent resettlement, and all that remained was for him or her to complete some sort of ministerial act of applying for that status, even if the individual did not choose to take advantage of that offer before coming to the United States. Applicants who received such an offer may nonetheless be eligible for asylum if one of the two exceptions applies. The first being that their residence in that third country was only incident to their flight from persecution, and that they stayed in that third country no longer than was necessary to arrange onward travel and did not establish significant ties in that country. Or the second exception that is probably most applicable in the Haitian cases, that the applicant's conditions of residence in the third country were substantially and consciously restricted by the authority of the country, such that the individual could not reasonably be considered to be resettled. In determining if this exception applies, adjudicators will consider several factors, such as the non-exhaustive list that's provided in the regulations, including type of housing made available to the person, the type and extent of available employment, and the person's ability to enjoy other rights, such as the ability to travel or receive education. The Board of Immigration Appeals, in the matter of AGG case on a previous slide, has set forth a four-step burden shifting framework for determining if the firm resettlement bar bars asylum to an individual. At the first step, the government bears the initial burden of showing by direct or indirect evidence, and there's some differences in the case law on this, but under this board case, that there has been an offer of permanent status. If the government fails to do so, the bar does not apply. If the government makes a prima facie case, the burden then shifts. And at the second step, the asylum seeker bears the burden of rebutting the government's evidence of an offer of permanent resettlement by showing by a preponderance of the evidence that the offer has not been made or that he or she would not qualify for the status that was offered. This could include evidence about how the law is applied in practice. Then after the asylum seeker has introduced rebuttal evidence, at the third step, the adjudicator considers the totality of the evidence presented to determine if the asylum seeker has met his or her burden to rebut application of the bar. If the adjudicator determines that the asylum seeker failed to rebut the government's evidence that they received an offer of permanent status in the third country, then at the fourth step, the asylum seeker must show by preponderance of the evidence that one of the two exceptions mentioned earlier applies. So, assuming that your client has spent time in Brazil before coming to the United States, the first step is considering whether the government has met its burden to show that the evidence indicates that the bar should apply to your client. Do not let the government off the hook. In many cases, the government will not be able to provide direct evidence of the offer. For example, a copy of your client's visa, because those documents are no longer available as many Haitians dispose of their passports en route from Brazil to Mexico. However, the government may also offer the indirect evidence that was mentioned, such as your client's length of stay in Brazil, receipt of government benefits or assistance, family ties in Brazil, etc., as well as general information about the immigration laws in Brazil offering status to Haitians. If the government has produced any evidence in your cases, we'd be really interested to see it, and thanks so much in advance for sharing it. There are two groups of Haitians in Brazil, and both may be considered to have received an offer of a permanent status, which could be sufficient to meet the government's prima facie case, though you should still, as mentioned, hold the government accountable to its burden to produce this evidence that would apply specifically to your client. If your client entered Brazil unlawfully, for example, he or she entered before January 13, 2012, before the humanitarian visas were available, he or she may have been authorized by a November 2015 resolution by the National Council of Immigration and the Ministry of Justice, which authorized some 40,000 Haitians to apply for permanent residence. If your client's name appears on this list, available at the link provided on the slide, this would seem sufficient to establish a prima facie case of an offer of permanent status in Brazil, and it may be difficult to rebut the government's evidence since an offer is considered made even if your client does not take advantage of it. If your client's name is not on this list, you should argue that there has been no evidence, direct or indirect, that your client had any sort of offer. Regardless, you may be able to rebut even if your client's name does appear by showing your client is not eligible for the permanent status that's offered, or if in practice these are not being granted. So far, we haven't seen any data yet out on adjudications of these permanent status available for Haitians and are working on getting that. If your client entered Brazil on a humanitarian visa, this visa was conditional for a 5-year period. It does, however, lead to a more permanent status at the end of the 5 years if your client can establish he or she is working and or otherwise able to support him or herself. Thus, if it is proven that your client had the humanitarian visa, this may be enough to meet the government's prima facie case that the bar applies. However, you could rebut by showing that your client is not eligible for the more permanent resident status that humanitarian visa allowed them by showing, for example, that they have no work available to them. In short, it is important to interview your client to better understand their specific status in Brazil and argue against the government's tenuous evidence if it clearly does not apply to your client's circumstances. Even if the government meets its burden and the judge determines you are unable to rebut application of the bar, you can still argue one or both of the exceptions applies in your case, and you should actively work with your client to understand if one of the exceptions applies. First, did your client go to Brazil just because it was an opportunity to escape persecution in Haiti? Did your client stay in Brazil no longer than necessary to arrange travel elsewhere? And did he or she not develop significant ties in Brazil? Or were your client's rights so restricted in Brazil such that she could not be reasonably deemed to be firmly resettled? What were living conditions like for your client in Haiti? Where did they live? How did they survive? Did they have the ability to move? Did they face any discrimination in Brazil? How were they treated in their employment, etc.? There are several reports and news articles documenting discrimination against Haitians and lack of employment opportunities, etc. And we're working to compile these articles and can share the resources with you to corroborate your client's claims. So that's a really quick overview of the firm resettlement bar and more to come on that. So we next wanted to provide some information on the resources that are available to you following this webinar. I'll briefly mention some of the resources we have available here at the Center for Gender and Refugee Studies, and then pass it back over to Steve. So at the Center for Gender and Refugee Studies, we have a technical assistance program where we provide legal consultation and litigation support materials to attorneys litigating asylum cases, including Haitian asylum claims. We have much of the information that has been mentioned here, and we'll make it available to you. We're also working with Nicole on developing an expert declaration on domestic violence and gender-based violence in Haiti that we hope to have available for attorneys in arranged cases relatively soon. And the link is provided in the slides for where you can request our assistance. Steve, I'll pass it back to you to talk about any additional information you wanted to share on your programs, and then I'll close it with a couple of additional slides, and then we'll move on to questions in our remaining time.
Well, I think I only want to stress that the Haiti Deportations Response Network has been a very effective way of getting experienced translators willing to work on the phone to attorneys all over the country needing them, and for various other things as well. We've mentioned you've mentioned your resource, which is very important, the Center for Gender and Refugee Studies. A link to get information from them that can be found on our Haiti Asylum Information Project web pages too. In terms of resources, those are the main things, I think.
Great, thanks so much, Steve. Somebody had asked a question about help with Creole translation, so that, for that person, they should join the network, and hopefully we'll hear a little bit more from you, or specifically reach out to you, I take it.
Yeah, that'd be great.
Okay. So last housekeeping matter is that if you're an attorney in California and you would like to receive MCLE credit for this webinar, please send an email to the email that's on the slide with the information that's requested. So we already have a couple of questions that came in. So in our remaining couple of minutes here, and we can go slightly over, but we want to be respectful of people's time, is that whether we have seen the firm resettlement bar issue involving Haitians living in Brazil with work authorization or residency. I can share that we have heard that this issue is coming up in the context of the CFIs. I personally have not seen the firm resettlement bar any decisions on it in the context of a merits hearing, so I haven't seen it be applied or overcome to answer that question. I don't know if any of the other panelists have heard specifically of the firm resettlement bar and any specific outcomes in cases, but it is something that we're tracking the trends of. A question was asked about downloading the slides. Yes, we will make the slides and the recording available to everybody, including the cases that were cited. And if there's any information that was missing, please don't hesitate to reach out to us. One question was asked about once they join the network, Steve, how will there be, sorry, I'm losing the questions. Where do they go for translators or translations once they've joined the network? Is that, how are you organizing that for people who are?
We've got about 200, we have about 200 plus volunteers who've signed up for this Google group. Scores of volunteer interpreters, dozens saying they're experienced. So, and I've had individual correspondence with many of them. So if somebody contacts me through the network or otherwise, you don't have to be a member of the network to contact me for information on any aspect of what we've talked about today. But somebody needing an interpreter, I just got a request this morning. I have a good list of 8 excellent interpreters detailing their experience, which I immediately was able to get out because we're getting many such requests. So I'm at steveforrester@aol.com, and glad to hear from anyone with any question related to any of this. Even if it's fact patterns you want to review, we can try to get it to Haiti experts who participated here and others, et cetera, et cetera.
Thanks so much, Steve. We're getting a lot of questions about specifics on application of the firm resettlement bar, and I just wanted to note that it is something that we're tracking, and we hope to have more information available working with a Brazilian attorney that could be used as rebuttal evidence in your cases or to help establish one of the exceptions. Unfortunately, I have not seen enough of these actually play out to answer the specific questions that are coming in. If you have specific questions about your cases, please do fill out a request for assistance on the CJRS website and share the trends of what's happening in your cases with the broader network. We're running out of time, so I want to close the webinar now, but we will take all of these questions that came in and try to answer them either by sending out more general information to the broader network or to you specifically individually. So I wanted to thank everyone for joining the webinar, to the Institute for Justice and Democracy in Haiti and the Harvard Immigration and Clinical Program, and Clara Syria for joining. So thank you so much, and we hope that this has been useful for you. And thanks again to Clinic for hosting.
Yeah, thanks everyone.
Thanks everyone. Thanks Blaine for running this, doing a great job.
Right. And this is being recorded for anyone who wants to get it, I believe.
Yes, it has. Okay, thank you all. Bye.
Thanks all.
Thank you.
I'll send these questions.